Good afternoon, Section Z. Just a short lecture on a topic we didn't get to in this morning's class. I want to take a look at the idea of just compensation. So take a look at page 623 in the Duke-Minier text. The Fifth Amendment says that private property can't be taken for public use without just compensation. The general rule that the court has applied in defining just compensation is fair market value. Now, the authors point out that fair market value may not always compensate fully for injuries the landowner suffers as a result of a taking. Presumably, that's why some people don't want to sell their land, is that it's worth more to them than its market value. Think about the Kelo case. Suzette Kelo particularly prized the neighborhood and the house and the location and the view, and the Dairies particularly prized the family history attached to their house. And so there are elements of value in property that are experienced by certain landowners that are not going to be compensated in a measure of fair market value. So if we know that there are some landowners who are not fully compensated for the injuries they suffer as a result of a taking, is the compensation really just? And notice the Supreme Court suggesting that the measure of compensation needs to be just both to the landowner and to the public. Basically, the court has been concerned that if you tried to compensate, for instance, for the sentimental value of particular property to particular landowners, that it would be very difficult to fairly assess that in a way that was fair to the parties. The only testimony, if you think about it, about how much sentimental value somebody places on a piece of land is the landowner, who, of course, has an interest in claiming perhaps more value than they really experience. And so some landowners might get inflated recoveries, and the measure of damages might overcompensate people if we tried to take those sorts of factors into account. They have some questions down at the bottom of that note that were worth looking at. So the first one here is, suppose that the government condemns part of a tract of land, and that the government's use of that land will reduce the value of the rest of the tract remaining in the condemnee's hands. So imagine that you've got a 2-acre parcel of land, and the government takes half of it, 1 acre, in order to expand a highway and increase the amount of traffic that goes over that highway. Well, you can imagine that the government taking half of the land for the highway expansion might also make the remainder of the property less valuable than it was before. And so what do we do about the fact that there is harm to the portion of the tract that remains in the hands of the condemnee? And the standard rule is that just compensation includes damage to the remainder that foreseeably follows from the government project involved, not just the portion that is actually taken by the government. Follow-up question, is compensation due if the government's use does not reduce the value of the condemnee's remaining land, but does reduce the rate at which it appreciates? And they cite a case here, Doyle from Alaska, that said that loss of appreciation of property is compensable if it represents value that would have been realized as of the date of taking if the taking had not occurred. Second problem in this bullet point here, may a city downzone property restricting its permissible uses so as to be liable in a subsequent condemnation action only for fair market value in light of the restrictive zoning? And they have a case from New Jersey, Riggs. And so hypothetically, imagine that you had property that was zoned for industrial or commercial use, and the city knows it wants that property later on, doesn't need it immediately, but for now it downzones it to residential so that its value will be lower. And when they do exercise eminent domain power, they can pay less for the property in a future condemnation action. The Riggs court says that an ordinance that's enacted solely to reduce a municipality's acquisition costs is invalid. But of course, the difficulty is proving that the only reason that the zoning was changed was to reduce future acquisition costs. That might be a difficult evidentiary burden in any particular case. And that is it for just compensation. We'll move on next to regulatory takings.